ICC was set up in 2002. Its creation was based on the legal foundation provided by the Rome Statute. More than 120 countries have since signed up to join the court. It's meant to be the last place of resort for nations seeking justice. The ICC's expertise lies with atrocities like genocide, crimes against humanity, and war crimes. The court's mandate is applicable only when an accused person cannot be investigated or prosecuted by the local judicial system. It also applies when a country attempts to shield a person from criminal responsibility. The court can also pursue cases if a country's judicial system has collapsed. The ICC can only investigate and prosecute cases that have taken place in a country that's already ratified by the Rome Statute, or when the accused is from a country that accepts ICC's jurisdiction. The country approaches the court to open a case. ICC prosecutors must then decide whether or not to open an investigation. Permission to do so needs the prior authorization of 3 independent judges. The UN Security Council is also able to request an ICC investigation, and only in that instance can the ICC launch a case in a country that's not a signatory of the Rome Statute. Leslie Marungu, CCTV.
The International Criminal Court was set up in 2002 to deal with crimes like genocide, war crimes, and crimes against humanity. It's based in The Hague, but can be held anywhere else in the world. Over 100 countries have agreed to participate, but the United States says it won't hand over its citizens if they are indicted. U.S. politicians don't want the ICC going after Americans. The court has been criticized for focusing on crimes committed by African leaders. So, the ICC sounds like a great idea in theory, but can it treat all countries fairly? The African Union.
Why does it always go back? Okay, all right. So we saw the video, all right. It's basic, idea down here, all right. What I want to point out to you, this slide down here, the similarities and the differences, right, between the ICTY, ICTR, right. So use the legend. Same like ICTY, ICTR, ICC, responsible for investigation, adjudication of different types of international crimes. Please remember to write in your exam, what is the what is the definition of international crimes? What do you mean, right? Like genocide, war crimes, crimes against humanity, rape, torture, things like that, right? And what you want to highlight, right, is that given the permanence, right, and the temporal jurisdiction, right, and the spatial jurisdiction. Temporal is time, spatial is space, right? That means across countries, lah. The way given the permanence, right, and the temporal and the spatial jurisdiction, all of these different crimes against humanity have been codified in a much more detailed manner under the ICC as opposed to ICTY and ICTR. Right, and but remember, the ICTR was instrumental, right, in codifying rape as a war crime, right? And ICC also, finally, discussed the idea of the long and recently long debated, only recently defined crime of aggression. Okay. So when you look at crimes of aggression, right? Okay, this was a very long-standing debate. There was a delay to push for it from about 1998, right? And it was only enforced in 2017, right? Conditions were met in December 2017, and they were able to establish it, right? Okay. So what does crimes of aggression basically refer to, right? Individual crime of aggression. So it's very detailed. Defined as the planning, preparation, initiation, or execution by a person in a leadership position, right, of an act of aggression such as the use of armed force by one state against another state, right? without justification of self-defense or authorization. So any kind of invasion by armed forces, military bombardment, blockade, all of these things, right, basically are considered to be an act of aggression, right? So there was a push for it, right, and the delay, they were pushing it for it from 1998. 2017 only they managed to enforce it, right? But the delay basically included a lot of negotiations as to what basically constitutes a crime of aggression, right? And what they were concerned about, right, is how will the ICC be able to exercise jurisdiction over a crime of aggression. So that was the delay, right? Because it is very important to accurately, carefully define, because if you do not accurately, carefully define what constitutes a particular crime, say like for example, what constitutes a genocide, it is on this based on this definition, right, is based on this definition is how action will subsequently be taken, right? And also based on this definition is who will get subjugated to under this particular crime, right? So who can it be leveled against and so on. So of course states who are negotiating are going to be extremely careful, because a too broad a definition can then subsequently turn into something that is counterproductive in their eyes, because if it's too broad a definition, then anything that comes remotely close can get them into trouble with the ICC as well, right? Especially if you're a state party, right? So that is, part of the negotiation. So one, it is important to, carefully define, because that is the definitive standard against which, it is going to be based on. Two, states are also thinking about how it will subsequently apply to them if, right, they are found guilty, right? So it is like twofold, okay? So COA was, part of the Rome Statute, right? It's supposed to be one of the core crimes under the court's jurisdiction, but because of this, lack of definition, Rome Statute, did not define the crimes, and it therefore it started, or they started working on it, only around 2010. So 1998 already, they mooted the idea. 2010 only, then they started to work on it. It took another 7 years, right, before they could actually decide how they were to define it. What are the conditions that have been met, and then they enforce it in 2017. So one, these are the kinds of indicators that critics point out to, right, and say that look at the amount of delay, right, that occurs in all of these establishments and negotiations, right. On one hand, the importance of taking time to sieve out these fundamental issues, right, and identify what is important, right, is necessary, because you're talking about application and interpretation of international law, right. And of course, based on the premise that individuals have to be proven guilty, right. So the I mean, innocent until they're proven guilty. So the rationale is that, of course, these exercise of due diligence is important, right? But at the same time, right, these are considered to be extreme delays. Delays are costly. Delays are costly not only in terms of resources, right? But it's costly in terms of, the longer it takes for something as significant as this to come into force, right, means that it doesn't apply to particular crimes that have already taken place, right? So, you have basically crimes that have occurred that are falling through these cracks, right? So it calls into question therefore the effectiveness, right? So how much jurisdiction do you have, what are the areas under which you have jurisdiction, how do you enforce it, and how much money have you spent, right, in attempting to enforce it, and all the delays, how much money have they cost, right? So that's basically what critics are always up in arms about. Okay, so this is an overview of how do you process the idea of criticism or critics who say that what has the ICC achieved, right, in the 20 years that it has been established. Okay. All right, temporal jurisdiction, right? Basically, what you want to highlight, right, is that it's built on the principle of individual criminal responsibility, But the logic is that, right, it's permanence, right? So anything, all right, before July 1st, 2002, do not fall, within its purview. That means anything after July 2002, right, basically falls under its purview, lah. Right? Okay. So the rationale is that, it's pretty much unlike, the timelines of the specific crimes that you saw under ICTY and ICTR. Like ICTR was specifically on crimes during the period of Rwandan genocide, right? The Khmer Rouge specifically in the period of the 1970s and so on, right? But this one is basically, it has jurisdiction, right, over the most serious crimes of international concern, right, committed after July 2002. So obviously, this permanence is what is making states, feel uncomfortable, because it is not anything that, can be basically dragged up, like, right? Okay. And then you've also got the territorial jurisdiction. All right. So ICC has got jurisdiction on the territory of non-state parties, right? If they're not members, as long as they have accepted the jurisdiction on an ad hoc basis. So I may not have ratified the treaty, but if I am agreeable, right, to the jurisdiction of the ICC, then the ICC can actually be effective in my state. All right. Okay. So it can actually, therefore, it can actually cast its judicial net, right, much wider, right, because even either I am a state party, right, or I accept the jurisdiction of the ICC, right. So that means, judicial net is obviously much wider, and then subsequently you also have this case, right, where you have a UN Security Council, right, that can refer the case to the ICC. So sorry. So when you have a scenario where the UN Security Council feels that a particular state has committed any one of the aforementioned international crimes, like crimes against humanity, genocide, crimes of aggression, and so on, they can actually refer the case to the ICC, right? Even if the territory on which these crimes took place on, right, were not a state party, right? So that means either you are a state party, either you accept the jurisdiction on ad hoc basis, or if you're not a state party and basically you don't accept the jurisdiction, right? It is a case where the UN Security Council says there's crime that is being committed and they refer the case, and therefore it can the ICC can have jurisdiction over that particular one. The Darfur case, right, in particular, was one of those that were referred to the ICC, right, in March 2005, right, and they opened investigations against war crimes, crimes against humanity in Sudan, right, since anything that occurred from July 2002 onwards. That means that is where the time period of the ICC being effective, right, it starts from July 2002. Then the Libya one also referred to the ICC by the UN, right, in February 2011, right. Each of these ones, I've given you the link, right, to the specific case. I like the ICC website because all the case details are mentioned. Who are the individuals? The latest statistics referring to how many arrest warrants, who have been arrested, who is having investigations conducted into, and so on, right? All of these details are available, on the ICC web pages. So I've given you a lot of links in the lecture notes. Just click on it, take a look at it, right? Quite interesting to read. Okay. Darfur is not a state party. All right. It's not a state party. All right. But the case was referred to the ICC by the UN Security Council. Okay. All right. So that is the key point. The Darfur case is important, right? Please pay attention to the Darfur case, particularly because of the Bashir angle, right? That one is used to discuss the credibility. All right, okay. Please watch this video, right? About the criminal court. How does it function? Wait, let me see. Hold on, Oh, okay. I've opened it for you already. Let's watch this video. Okay, inside the criminal court. Is it this one? This is not the one. Hold on. Sorry, this is the wrong video. I opened the wrong video. Wait. Okay. Sorry. Wait 1 second. Okay. Let me share screen.
The International Criminal Court is different from other international courts in that it was established by an international treaty and not by the United Nations. The ICC has jurisdiction over 121 states, which have signed up to the Rome Treaty, and the United Nations Security Council can also oblige a state to cooperate with the court. The ICC is made up of 4 organs: the Presidency, the Judiciary, the Office of the Prosecutor, and the Registry, which provides logistical support to the other 3 parts of the court.
The presidency of the ICC is responsible for the proper administration of the court. The presidency administers the judiciary of the court. When you have an actual case, you need to select judges to sit on a bench to hear the case before the court.
The judges are elected by the member states. There are 2 routes to getting a case before the court. One is for the individual state, which is a party to it, to invite the court to prosecute. The other is where the Security Council of the United Nations initiates a case.
In some instances, the Office of the Prosecutor can also initiate an investigation.
The judiciary of the ICC consists of 18 judges that are all elected for a 9-year mandate, and which cannot be renewed.
The Chamber strongly deprecates the attitude.
And the judiciary is really the core of the ICC. They are the ones who ultimately decide on anyone's guilt or innocence. You have a prosecutor of the ICC who conducts investigations, collects information, and then presents this information or evidence to the judges. They are the ones who decide whether there are actually grounds, for instance, to issue an arrest warrant. Are there actually reasonable grounds to believe that this person may be responsible? Again, it is the judges who, having heard what the prosecutor has to say, what the defendant has to say, whether there are then grounds to proceed to a trial.
The Office of the Prosecutor, in particular, has to determine whether there's a reasonable basis to proceed with an investigation. So what that means is that we do an analysis of information received at the very preliminary stage to determine 3 things. 1, have crimes occurred which fall within the jurisdiction of the ICC? So we have to determine, do we think that crimes against humanity, genocide, war crimes have occurred? We also have to determine whether those crimes have been committed by an individual who belongs to a country that is party to the Rome Statute, or whether those crimes have been committed on the territory of a state that is party to the Rome Statute. We do this assessment in a division of the Office of the Prosecutor called the Cooperation Division.
The other 2 divisions of the Office of the Prosecutor are the Investigation Division and the Prosecution Division.
The last prong of our preliminary examination is we have to assess whether there have been national proceedings, because the court will only step in if there has been a failure by national jurisdictions to genuinely prosecute international crimes.
The Registry deals with all of the logistical matters which make the court run smoothly. They recruit and train all the translators, as well as arranging victim protection and transport to The Hague. As the ICC does not have a police force or an army, it has to rely on the cooperation of states who have signed up to the Rome Treaty to enforce its decisions.
In some instances, even if a state party has joined the Rome Statute, they may have reasons why they're reluctant to fully cooperate.
I think the biggest flaw in the court is the absence of any enforcement powers. Unless states want to cooperate with it, there's very little that the court can actually do to require them to do so.
There are 12 individuals who are suspects against whom there are allegations of genocide or crimes against humanity or war crimes. 12 persons are currently still either at large or have not yet been transferred to the ICC to actually face these allegations before the ICC's judges.
A very famous international judge, Antonio Casese, once described international criminal courts as being giants without arms and legs, and the arms and legs were state cooperation. And what we haven't had is much state cooperation in relation to many of the investigations.
This system of international criminal justice holds the potential to help prevent crimes against humanity, war crimes, genocide. These are crimes that can destroy communities, they can tear societies apart, and it will take decades, it will take generations to try to repair the wounds. So anything you can do to prevent that is really worth the effort.
All right. I like that argument where he said, the arms and the legs of the court, right, are the state cooperation, right, and the states, not wanting to cooperate is what basically has, negatively impacted, right, the success or the effectiveness of the ICC. It makes a lot of sense, right? Okay, right. That is actually a very good analogy actually to use. Okay, all right. So what you want to pay attention to, right, are the different organs, right, like what was mentioned in the video just now. Okay, so you've got the presidency. This is something that the legend still applies, right? So can you see the legend down here, right? It's not equal sign, right? So the legend still applies in the sense that this is not something that you saw under the ICTY ICTR. So presidency basically they're in charge of the administration of the court, right? The OTP, remember, even under the ICTY ICTR, the OTP was actually independent of the main administration. Why? Because of the need for it to remain untainted, right? Therefore it is independent, right? But it is otherwise, the presidency oversees the administration, the registry, and so on. Presidency coordinates and then works together with the chief prosecutor or the office of the prosecutor, right, on any kind of matters of mutual concern, right? Okay, and then the presidency as well as the OTP are seen to be the most visible organ of the ICC, right? They are tasked with promoting public awareness, international relations, and so on. This is important. Why? Because very often you have international organizations that do not have enough coordination, right, with local governments, or they do not have enough outreach, on social media and so on, right? So it is important, especially in this day and age where people, are very concerned. The international community and individuals, right, are very concerned about the reach of government agencies, of the reach of international organizations. What are they, spending money on? What are they attempting to solve? Right, largely as a result of the idea of shift in values, visibility being increased as a result of social media, news, right, all the drivers of globalization and so on, right? So that is why public awareness and understanding of the ICC becomes also an important point. Then you also have the discussion of the chambers, right? Okay, so again, the chambers and the judicial divisions are quite different, right? Compared to what you saw in the ICTY ICTR, you had only like 3 judges and then 5 in the appellate chamber in the ICTY ICTR. But now you have 18 judges. The way they sit in the individual chambers, of course, is similar to ICTY ICTR, but total, you've got 18 judges, right, elected by the ASP, right? And then you've got pre-trial, you've got trial and appeals, right? And they all serve 9-year non-renewable term, same as the chief prosecutor. So what is significant is that remember what the the lady mentioned in the video, right? The pre-trial, they need to conduct an investigation. They need to find out whether, okay, the ball has been dropped on this particular crime, right, domestically, and therefore the ICC needs to step in. Number two, they also need to establish, right, that is why the definition of what crime against humanity or crime of aggression is important, because they need to define and identify, has this particular crime actually taken place, right? So that is, why the pre-trial is important. If, they cannot justify opening up an investigation, then, they cannot go ahead with it, because like once they open up an investigation, it becomes very costly, right? And then the moment they open up the investigation, they have to start gathering evidence and so on, right? So that is why the pre-trial is also, very significant, right? Then you have the OTP, okay, right? So like, what we mentioned, the OTP is one of the most significant, right? Is responsible for receiving referrals, any substantiated information on crimes, right? They are the ones that conduct the investigations, the preliminary examinations, the prosecutions, and so on. And of course, the as a result of the Rome Statute, right? And the principle of complementarity, right? The ICC OTP, right, was basically given less scope for maneuver, right? They are actually more highly dependent on the UN Security Council, given the fact that the permanence, right, is what they force them to force the negotiators to basically want to curtail the powers, right? So basically, what you see is they are elected, right, for a term of 9 years, right? Former one was Fatou Bensouda, right? The current chief prosecutor is Karim Khan. He came into the office since June 2021. Take a look at the read. The link I've given you, right? On Fatou Bensouda. That one gives you a nice summary, right, of some of the cases, the important or significant cases that Fatou Bensouda has basically been faced with, and she has received both praise as well as criticism. They say that she has actually opened a lot of investigations, like the Rohingya. She opened investigations into US, right, and she was the one who was denied the US visa. Sorry, she was the one that was denied the US visa, by Trump, right? And then Biden basically revoked, that executive order. And she's also been criticized, for a lot of backsliding under her, right, of the ICC. But that is, basically an interesting article, right, that summarizes some of, the work that she's done, right? It also gives you, it's like a cheat sheet, right, of, because the work that she's done is basically the work of the ICC, right? So it gives you, it's technically functions as a cheat sheet, right, on some of the different activities or incidents that that have been investigated in. Okay. All right, then you've got the different divisions, right, under the OTP, right? So you've got the jurisdiction, complementarity, and cooperation division. That looks at preliminary examinations, investigations. Then you've got the investigation division itself that starts to look at field deployment of staff, looking at crime analysis of all the information and evidence. And then you've got the prosecution division, which basically looks at litigation. That means the ones that actually conducts the prosecution. How can the law be interpreted and applied to these particular cases, right? They submit the cases, the litigation, or they submit the summary of the case to the judge, right, and so on. All right, so that's basically what the OTP does. Then you've got the registry, right? Registry is important, right, because like what we saw in the video last week. Remember, we saw the did we see the video? Yeah, I remember we saw the video, right, on the UNDU and the registry. Basically, the registry is similar to what you saw in the ICTY, ICTR. They provide basically a support. They play a supporting role, right? They engage in non-judicial activities like outreach, They have, support to the defense and the victims' lawyers. They ensure the well-being of those that have been prosecuted by the courts or who are awaiting trial and so on, right? You've got two Office of Public Counsel, the OPC, right? You've got two independent officers, right? You don't see this in ICTY and ICTR, right? There's two Office of Public Counsel. One is for the victims, right? So the role is to ensure that the victims are able to participate effectively in the ICC proceedings. They provide legal advice to the victims, to the lawyers, and so on, right? And then you have the OPC, right, for defense, right? That means it's for those who have been arrested, right, and have been accused, right? So it serves as, for those standing trial, right, provides them some defense, right, to the lawyers, to the accused, right, similar to the public defender office, right, like what you see in domestic courts and such, right. So if you cannot afford a lawyer, then you've got a public defender, office that may help you, right. So there are two separate, councils, right, public councils for, sorry, that's my email. There are two public counsels, right, for the OPC, for the victims as well as for the defense. Okay, all right. All right. Then you've got the trust fund for victims, right? Again, this is not something that you tended to see in ICTY and ICTR, right? And the rationale here is that, remember we talked about, how the purpose of the ICTY and ICTR, and then of course the ICC also, right, is about the rehabilitation, about sustainable, lasting peace, the idea of restorative justice and reconciliation. Once the victims have confronted the perpetrators and given their first-hand accounts and basically have the ability to question the perpetrators and hold them accountable, right, and if the perpetrators are put away, then what is the next step, right? The next step is obviously the restorative justice and the reconciliation. Basically, to sum it up, is like moving on, right? So the trust fund basically assists this idea of allowing victims to move on, right? So addresses whatever kinds of harms, like post-traumatic stress disorder, right? Psychological, physical, material support, right, to the victims and their families, to ensure that whatever reparations that the perpetrators commanded, right, by the court to provide, then the trust fund also helps to implement all of these reparations and so on, right? So the intention behind it is to help victims return to a dignified and contributory life within their communities. Maybe you want to write this down. This is something that we need to take with a pinch of salt, right? Just because you have a trust fund, just because you provide some kind of physical or psychological or material support to the victims, it doesn't mean that they are going to be able to return to life as it was prior to the crimes. It is an attempt to do so, and an attempt to ensure that this happens, right? And the provision of the funding, right, to ensure this happens is necessary. It's admirable, yes, right? But we also must think about, from a rational perspective, don't oversell this point, right, in your exam, by saying that, oh, everything goes back to normal and citizens are all happy and they are able to overcome the trauma. Please do not make such sweeping statements in your exam answer, because that is not entirely true. If I was the marker, I would say, like, so just because you have a trust fund, does it really mean that the horrors that they've undergone has been wiped out? So again, that goes back to the more fundamental question. Remember, I always make this point, right? The the structural root cause, right? Structural root cause, it still doesn't get addressed. You may have accountability, right? Being leveled against this. I mean, the perpetrators are being held accountable. They're punished, right? But then it doesn't go towards the idea of preventing, right? Any of these crimes, right? Those that are determined. Like, remember what we argued, last week. The argument goes two ways, right? When you look at deterrence, right? One, deterrence, tells us that, yeah, states and individuals, they are going to be more cautious, right? Thinking about whether they can easily be hauled to court, right, as a result of this permanent court that exists. But does it really address the structural root cause of what motivates individuals to engage in genocide? Does it really address the structural root causes of what motivates individuals to engage in torture of other individuals, right? So that is what you really need to be careful about when you discuss, right? These kinds of logic of deterrence and the logic of helping victims to return to a dignified contributory life, right? We need to point this out. A thinking student would think about this. Of course, if there's no reason for you to include this in your argument, then of course don't bring it up lah. But the logic is that if it talks, if you get a question, a very open-ended question, right, that really talks about the effectiveness of the ICC, right, and then it is up to you to discuss what constitutes effectiveness of the ICC. And if you want to include the idea of this restorative justice and reconciliation as part of the effectiveness of the ICC, if you want to talk about deterrence, right, that some claim, right, that courts like the ICC, permanent courts like the ICC may level, right, then you can bring this point up, right? But if it's a question on, say, for example, strengthening the international legal regime, then I wouldn't see any place for this argument, because when you talk about strengthening international legal regime, we're talking about the technicalities that the ICC contributes to, right? So there are two different ways to look at it. Is whether what the question is, how do you interpret what the question refers to, right? Whether your interpretation is accurate, and whether you can include the argument or not. So don't just anyhow try to squeeze things in where it doesn't have a place in the point itself, right? Okay. Any questions so far? Sorry, I anybody? Any questions so far? Anything? Anybody wants to double check or I want to ask? Anything? Okay, all okay, yeah? All right. Okay, this one, please highlight this or asterisk it or something. Very important. Okay, this is the one that's telling you the principle of complementarity, right? Okay, so this one is something that is you have to include in your exam answer. All right, okay, no exam answer on ICC should go without discussing Rome Statute and the principle of complementarity. All right, and how this differs from the ICT by ICTR, number one. Number two, how this basically makes this more less sorry, how this makes ICC less effective than the ICTY ICTR, right? Because you have got a distribution of competences. If you remember arguments related to federalism, and we talk about the idea of competence, remember what competence refers to? Competence refers to areas of jurisdiction. It means, what do you have jurisdiction over? What do you have control over? The different areas that you have control over, right? So what happens is, at the Rome Conference, right, and via the Rome Statute, they dramatically altered it in favor of the sovereign state. So it is no longer in favor of the ICC. The ICC was basically made subordinate to the national courts, right? So the idea is that, if it, remember what the video highlighted, right? only if it has been proven, right, that no action has been taken in the first place, right, by the domestic courts, then only ICC can step in. So if that's the case, that means the ICC is subordinate, right, to the national courts, because that has to be the first step, basically highlighting the primacy of the national courts. So that is where you get the idea of the principle of complementarity, right? The ICC was basically intended to complement and not replace the national criminal system. So the ICC cannot say, we see this crime occurring, we're going in, right? It doesn't work like that. So the principle basically functioned as a concession to states, during the Rome conference, right, who were fearing the implications of too powerful an international court and too powerful an international prosecutor. Beautiful line to use in your exam answer. Too powerful an international court, too powerful an international prosecutor. Why were they so fearful? Number one, permanent status of the court, right? Number two, the jurisdiction, temporal as well as the spatial jurisdiction, much broader than that of the ICTY and ICTR. Anything after 1st July 2002 can basically be investigated by the ICC. Anything that occurs on the soil of a state party can be investigated by ICC. If a non-state party, right, agrees to ad hoc jurisdiction, investigation can be opened. If investigation is referred to by the UN Security Council, right, also if a complaint is referred to by the UN Security Council, investigation can be opened, right? So the jurisdiction obviously is broader than that of the ICTY and ICTR, right? So, the logic is that, even if you're not a state party, the ICC can still find a way, right, to basically open up an investigation, right? So if you don't, impose this principle of complementarity, then the logic, right, is that the ICC would actually become too powerful, right, in the eyes of the sovereign state, right? So that is the rationale down here, right? So is that what the international political system actually requires, right? As opposed to IOs that are simply powerful to some extent, right? Do we actually, want international organizations that have the potential, right, to do so much more, but their potential is always curtailed by these kinds of safety valves, right? That is, one of the main questions, that I had when I was reading and looking at all of this material, right? Is this what we want IOs to be like? Do we want to curtail the powers of IOs, to make them subjugated to the sovereign state, right? And if you come from the sorry, if you come from the realist or the Marxist perspective, when you say that IOs, at the end of the day, simply function as vehicles for great power interests, right? For capitalist Western hegemonic interests, right? And therefore, what good are IOs? We've invested too much faith into these IOs, right? Not enough powers. They have no teeth, right? Is this what the international political system basically requires, right? Or do we require strong international organizations, right, that have the ability to actually do what they set out to do? Is there a problem, right? Would it have actually been so wrong, right, to allow ICC, to have more powers? That means, to not have this principle of complementarity and not dumb down its powers and not give sovereign states a safety valve. Would that actually more effectively strengthen the international legal regime? Would that amount to strengthening the international legal regime, right? Or would you still rather an international organization have a safety valve, right, that allows states to keep the international organization at arm's length, keep the ICC at bay? Think about this. I think this is an important question, right? It is a thinking question, right? It's something that you need to consider when you are thinking about What can we do to make international organizations more effective? Number one. Number two, is there any real danger, or is it perceived danger that we are constantly harping about, right? Okay, so think about that, right? This is not only something that is applicable to the ICC, but it's an argument that is applicable to international organizations in general. But I would, I specifically bring this up, during the discussion on ICC, because the logic is that this is an organization that is dedicated to addressing crimes against humanity. It doesn't get any more unselfish than this, right? Because this is really about for the people, right? By the people, not by the people, sorry, for the people, right? Not democracy. It's about it's really for the people, right? So and with human rights, with human development becoming something that is gaining more attention, human security gaining more attention higher up on the international political agenda, right? Would really the strengthening of the ICC equal to the strengthening of IOs in general, right? That's the logic. Would it, actually then only contribute to the strengthening of the international regime? The international law regime, right? The principle of complementarity has basically ruined this, right? This safety valve, right? So basically, the drafters of the Rome Statute, they abandoned, right, the principle of concurrent jurisdiction, right, and they provided that the ICC can only investigate, prosecute possible crimes if and when the state that has jurisdiction either totally unwilling, right, or unable to genuinely carry out the investigation, right? So Sudan basically was totally unwilling, and therefore the ICC was able to step in. Even then, ICC was able to step in, right? But Bashir has been running around, right, freely attending events. He was spotted at events by the African Union per se. He was attending meetings. He went to meet Xi Jinping, right? And then they had this group meeting where they hugged each other and they called each other brother and all these things, and so on and so forth, right? And then finally, right, last year, and was it last year? Yeah, it was last year. Last year, Sudan basically, said, yeah, I think it would be a good idea to hand Bashir over to the ICC. So they made that, concession, but they didn't say when they're going to do it. And up till now, nothing has really been done, right? So again, it remains, this principle of complementarity basically has empowered states vis-a-vis the ICC. And is that what you want? Is that what is needed in the international system? Okay. All right. So this is why this argument is so important, right? Okay. So these are some arguments here, like on this slide I've already highlighted to you, right? Like I already said, if the ICC, right, is not significant, right? Why would global or regional powers be fearful of it? Why would they oppose it in the first place, right? If it was not significant, 20 years, it's a little bit too early to judge very conclusively, right, whether the ICC has indeed been successful, right? There have been notable cases, right, and it is seen as a court of last resort, right? Where local jurisdiction cannot be enforced, and the ICC is obviously a useful option. So it is not it is not a case where you can write an exam answer and say the ICC is ineffective. Like how you write off AU, for example, right? There's more opportunities for us to critique African Union, for instance, to say that it's not very effective, right? These are all the failures and so on, right? Or you criticize the IMF and the World Bank very heavily because of the damage that is leveled via the structural adjustment program. But with the ICC, I find it very difficult to do that, right? Because notwithstanding the criticisms of spending so much money, notwithstanding the criticisms of the long drawn processes that are involved in prosecuting the cases and so on, we cannot turn a blind eye to any of its effects and say that it is something that we're better off without, right? I don't think any rational argument can actually make that argument and get away with it. Okay. All right, so these I updated this, right? So this is a total of currently total of 16 situations under investigation, do take a look at the one that I've given you, the iccforum.com Africa, right? That is where they have basically highlighted uh, the arguments, right, that a lot of these African states and African leaders have pointed out that the ICC is an African court, right? So this is where I ask you, is there a trend? Because I mean, let's look at it, right? Uganda, DRC, Sudan, Central African Republic, Republic of Kenya, Libya, Ivory Coast, number 7, Ivory Coast, Mali, right? Georgia, Burundi, right? Not right, Burundi. Yeah, these are all, majority of it is actually, states in Africa, right? The state of Palestine, new one has been opened in March 2021, right? Afghanistan, March 2020, and Venezuela also November 2021. Okay. Look at number 11, Burundi. So because Burundi left ICC, they withdrew from ICC in 2017, right? So what happens is that whatever crimes, the investigations have been opened, but they can only investigate up till October 2017, unless another referral is made, say like via the UN Security Council, for instance, right? Okay, so that is the rationale down here. So the same thing applies to Philippines as well, right? I've got the detail for you in the subsequent slide. So these are some of the cases, right? I think it would be good for you. I'm not going to run through, each of these cases, but what I'm saying is that I think it would be good for you to have an example of at least, one or two of the hot button cases, right? Say, like, for example, the Bangladesh or Myanmar one, right? How did it, get referred to the ICC, right? So, Myanmar not state party, right? But Bangladesh ratified the Rome Statute, right? So, the chamber basically looked at, the preliminary investigations, and they said, yeah, okay, we can, basically look at the Rohingya incident, right? And we can, think about in opening up an investigation, right? For the persecution, right, against the Rohingya population, right? Okay, so take a look at, the individual cases. This is the one I was telling you, the Philippines one, right? The Duterte's war on drugs, right? So, when they opened up the investigation, Philippines basically withdrew from the ICC. So what happens is that the ICC only retains jurisdiction, right, from 2011 up to 2019, right? So, because that is the 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 space of time, the span of time, not space of time, sorry, the span of time, right, that it technically was ratified as a member, right? So same as like the Burundi one, right? If they want to look at anything after that, then subsequently it has to be referred to by, the UN Security Council, or Philippines, basically, or Burundi, right? In both cases, they would have to accept jurisdiction of the ICC. Okay, so this one is important. Just this is just important to know, right? So that you can explain it, right? How the ICC's powers apply, right, to the individual states. What happens if you have a state that withdraws and so on. These kind of technicalities important because this affects the jurisdiction of the organization, right? So we've got about 6 cases that are closed, right? Charges, either acquitted, withdrawn, vacated, right? So what happens is that cases can be closed or withdrawn if there is a lack of evidence, right? Or if the defendant, right? That means the one that has committed the crime, right? Basically dies, right? Okay, so obviously, they would have to, withdraw the case or close the case. Lah. Or you can also have a scenario where they withdraw or close the case if the judge decides not to confirm the charges, right? Or not to, commit trial due to a lack of evidence, right? Sometimes if they receive new evidence, they can actually reopen the case, right? But, very often, right, what happens is that there's a lack of evidence, right, and this is what sorry, there's a lack of evidence, and this is what contributes to the delays, right, and then the scenario where they cannot continue to prosecute because there's a lack of cooperation and even a lack of difficulty in the arrests, right? So you've got a lot of them who are at large, states are unwilling to cooperate. How do you expect the ICC to gather enough evidence and successfully conclude the trial? You can't even arrest them to start off with. and states do not want to cooperate, right? So that becomes very problematic, okay? All right, okay. So, basically, one of the biggest challenges, right, that the ICC have faced is, this criticism, right, that, is it a court for Africans, right? Let's watch the video. Okay, hold on, let me share screen.
Africa feels targeted, rightly or wrongly. It's like only African leaders are being arraigned before the ICC. And so Africa feels
with
targeted.
African support.
It is correct to say that most of our cases, or all of our cases at the moment, are in Africa. But that is not the whole picture, Tim.
The International Criminal Court, from its own record of the work that has been done since the Rome Statute was adopted, shows clearly, with no shadow of a doubt, that it is a court created for Africans, and it is used mostly by Europe to manipulate African politics. You cannot tell me.
Where does the ICC chief prosecutor come from?
Where is a white man?
Where
is a white man convicted by this court from the moment it started? Are you telling me there are no crimes in parts where people have a lighter skin? We don't believe in that
Minister,
court.
should we look at the facts?
We never wanted to belong to the Rome Statute.
Should we look at the facts? You're losing Africa's participation in this court.
I don't think I am
That's
losing
a central
Africa.
blow to the credibility of this court.
I do not think that the voices of a few leaders or a few people from Africa should be used to disregard the support that we still have in Africa.
Right. Okay. So, I like the, the way I like that particular video because, it asks the two fundamental questions, right? Where is the white man, who has been, prosecuted by, the ICC? And then, his response back is like, where does your chief prosecutor come from? She comes from Gambia, right? So, the logic is that, it's basically helping Africa, right? That's what Fatou Bensouda has highlighted. It's not a case where, instead of thinking of it as being as the ICC targeting African states, right? Fatou Bensouda says, think of it in the other way, right? It is actually helping Africa by prosecuting the criminals who have been conducting crimes of aggression against its own citizens. But the other question, right, is that how come, you see so many of these investigations being opened up on African states? Go back to the first lecture that we had on Africa. Remember the one where we did the OAU, right? And we introduced I introduced the background of Africa to you. You can come, to this argument with that background, right? Look at the instances of conflict that arise on African soil, right? Why do you see a propensity for these kinds of conflicts to arise? Because of the cross-cutting cleavages, because of the scarce resources that those that belong to these cross-cutting cleavages are basically attempting to take hold of, because of the power vacuums, right, that have arisen in a lot of African states, because of the instability, a lack of good governance, a propensity of weak, institutions. Remember that phrase that we use, the deadly cocktail, right? You have instances and all of these problems being exacerbated by instances of climate change, famine, shortage of food, and emphasis on the lack of food security or water security and so on. So the high levels of high levels of human security being impacted, right, in the African continent, right, is something that it's not to say that human security is not affected in other states or in other continents, but you do see this happening fairly frequently, right, or at an alarming rate, right, in the African continent, right? So that also is another reason why maybe you have a lot of cases being, highlighted, and then therefore they open up the investigations because it's glaring, right? So is that argument, that she made, is it justified, right? Okay, right. Of course, what makes them want to criticize this, right, is that criticisms abound because for the longest time, right, American and British actions in Libya, Afghanistan, they had basically escaped the reach of the ICC. So I guess that is what prompts them to respond in that way, right? But that is not to say that non-African states have not had any investigations opened up, like you saw just now. Venezuela, right, Georgia, Philippines, and so on, right, have been also, have have investigations opened up, right? Okay, so that is something that you want to highlight. So ICC has consistently denied any kind of African bias, right? They highlighted that even in some cases like cases like LRA in Uganda, right? Gabriel, hold on. Cases like LRA in Uganda were actually self-referred, right, by the country, and then you have other countries, other cases that were referred to by the UN. Okay, um, and if you look at the the criticism, right, of course it's odd that American British actions have not been they've escaped the reach of the ICC. So the logic also is that those that are asking these questions, how come, yeah, okay, your US and is not a state party, why is it that the UN Security Council did not refer these cases to the ICC? So how do you explain these kinds of anomalies, right? And how does this affect the effectiveness of the ICC subsequently as an IO, right? Because of this supposed discrepancy in how they examine these cases. Gabriel, so it can be said for the claim that ICC is an African criminal court, it is because statistically, empirically, more human rights violations occur in that region or developing states. No, 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 no. I do not want to, because if you say statistically more human rights violations occur in that region, then that would be akin, then what you would need to do is provide evidence to show how many more human rights violations occur there vis-a-vis other states. That will be getting yourself into a bit of trouble. But what you want to do is, I mean, the logic that you're trying to explain is correct, right? But soften the argument, to say that there have been several instances, right, that have been helped along, right, by these high levels of instability, right, that have been caused by human security issues, that have been caused by environmental degradation, caused by weak governance or poor institutions, and so on, that have um, led to a propensity of several of the and the demographic makeup, right, of the states have contributed, right, to several of these conflicts arising, right? And when they want to solve the conflicts, they sometimes turn to war against citizens, crimes of aggression, rape, and torture, and all of these things. So in that way, if you say that empirically and statistically human rights violations occur, right, then you're basically saying that human rights violations do not occur at a high rate in the US or in UK or in other states, and that would then that would actually turn the direction of your argument, right? And the marker will basically be will be basically asking you, so you're basically saying that only that human rights violations occur at a higher rapid rate in Africa versus other states, is it? Then and how are you going to prove that? Gabriel, you understand? You understand why? Yeah, you need to nuance it, because if you're going to say it like that, I think it's very dangerous. So what I mentioned just now is that the characteristics inherent to the African region, right, may likely explain to us why do you see a higher instance of these kinds of conflicts occurring, and therefore, right, investigations get opened up. You understand? Yeah. So it's the other way around. Otherwise, we're taking it like a bit too far, lah. right? And it becomes very problematic because then you cannot justify. Okay, Ken, all right, okay. Okay, so the idea here, right? That you want to talk about the logic of peace and justice, right? Okay, it is it is absolutely necessary, right? But it what it does is that it basically holding them to account, right, is absolutely necessary. But if the key individuals and the state itself refuses to cooperate, then it becomes a issue of jeopardizing long-term peace, right? You're going to be unable to you know, uh, you know, uh, create any progress, right? Because, say, for example, in response to the arrest warrant in 2009, 2010, in the case of Sudan for Bashir, right? They, as a retaliation, right? The Sudanese government basically expelled any kind of humanitarian aid agencies, right? And in the end, what happens? Remember, I've used this phrase before. The citizens are the ones that are doubly disadvantaged, right? Because basically they are denied any kind of help, right? Or in this case triply disadvantaged, right? Because number one, right, in the first place, if we look at Sudan itself, right, number one, they have already suffered the war crimes at the hands of a president who was neither representative, right, who took care of the welfare of the people. Number two, there's a lack of retribution or justice for the suffering endured because he's still out there enjoying his life, right, and he's not been arrested just yet. And number three, right, as a retaliation when they cut off the humanitarian aid, right, the individuals, the citizens were actually cut off from resources and aid that might have alleviated some of their suffering. So in this case, right, it basically, I mean, it's not to say that it is the fault of the ICC, right? It is just that this combination of various factors, is primarily stemming from the fact that the state and the individual refuse to cooperate, right? This is what contributes to the suffering of the people. So please don't write it in the wrong way and say that, oh, the ICC is the one that's contributing to the suffering, by actually opening up the investigation. You can't say that, right? Because the ICC is actually, the intention is actually to indict him, right? But the unintended consequence, right, is that as a result of the ICC wanting to indict him, that I mean, they did. Who would have thought, that they would basically come up with this kind of reaction, right, by cutting off the humanitarian aid to their own people, right? Because why? The structural cause of that violence is not actually addressed, right? So they respond, right, by hurting the people even more because that structural cause of the violence still remains as it is. Okay, all right. The Omar Al-Bashir case, right, instrumental, right? I think, if there's any case that you look at in the ICC, you should look at the Omar Al-Bashir case, right? That is, very significant, right? He's openly flouted the ICC's arrest warrant, right? Like, say, for example, South Africa, they had basically, allowed him to, fly back to Sudan. He visited, he left without any kind of arrest and so on, right? South Africa was basically seen to smuggle him out, right? Several different articles, right? And then I've given you the one right at the bottom, right? Sudan, in 2020, 2000, yeah, correct, 2020. 2020, Sudan basically, agreed that, Bashir should basically, face up to his crimes, right? And then they say, 2020, they say he should face. 2021, they basically say they will hand over, right, in August 2021. But they did not give any kind of, timeline, right? So it's like they're basically just waiting, right, for, Bashir to be handed over. Right, so several different cases, sorry, several different charges, against him. Initially I initially thought that that he had already been arrested because when they said that they will hand him over, I thought that, oh, this he'll be arrested soon. And when I double checked again, I looked at the case. He's got his own page in the ICC, right? And then it says he's at large, and I was thinking, how come the state, it's almost like as if they're buying time, like they do not want the ICC to be continuously on their back, right? So they're buying time by saying we'll hand him over, but still haven't still haven't done anything relating to that. So genocide, murder and torture, in war crimes, right? These are the three main charges, you know, that have been leveled against him, right? Right, so he's wanted on a total of 10 counts, right? You know, I've given you the details down there, right? And then basically, you know, I like that quote, right? Bashir has come to represent the confusion of international law over crimes perpetrated by sitting heads of governments, right? And you know, you can't, and at the same time, it also brings up the African bias point, right? And the the logic, you know, that has been put forward, right? You know, if your white Western war criminals are roaming free, then we, right, referring to the Africans, reserve the right for ours to roam free as well, right? It's a self-harming logic, right? But basically, this is how critics, right, of the ICC basically look at it, especially the African critics of the ICC. They look at it in this way, right? Okay, so you know the logic is this: when you look at the you know, Bashir case, right? You know your question basically is this: how useful is the ICC when it can't arrest or it can't compel arrest, right, of those it wants to try for crimes, especially when the state parties are not compliant, right? So you know Jordan didn't arrest Bashir because they did not want to jeopardize their relations with other states, right? Despite you know the arrest warrants in 2009, 2010, right? Bashir basically made about 150 trips within Africa. So this is that self-harming logic, right? You know, you don't want to do anything about your white Western criminals, then we also will allow him to roam free, lah, right? So made 150 trips within Africa, China, Saudi, Egypt, Jordan, right? All of these, you know, different, you know, places, you know, that, you know, he went, right? Okay. Then, you know, basically what you want to, you know, highlight, right, is that, you know, this is what Bashir's case basically, you know, represents, right? So, you know, the case also, you know, highlights this, right? US selective behavior. They didn't want to, they abstained from referring Sudan's case to UNSC, but they voted in favor of referring, you know, Libya, right? So, you know, it suggests that the US supports the ICC only when it suits its foreign policy agenda, right? It uses the threat of this prosecution, right, to skewer its, you know, foes while protecting its friends, you know, from its reach, right? So, you know, you can look at Kant's Means and Styles, page 507, right? You know, they refer to Libya and Syrian cases, right? If you want more examples on this, you know, selective approach, right? So, you know, the rationale really is to think about, you know, this logic about how the selective approach of all of these different, you know, states, it undermines the credibility and the operations of the ICC, because what it looks like in the end is like it looks like a pawn in the hands of these great powers, right? It's politicized, right? And it is used, you know, according to what the great powers basically want, right? So, you know, if states, you know, reject the court's indictment, right, you know, with the defiance of the perpetrator to be arrested, then ICC's legitimacy obviously is tarnished, like, you know, what you see with Bashir's case. If states, you know, cooperate and then don't, purely out of, you know, political motives like the selective approach like the US, right, then ICC's, you know, credibility as a judicial body is also undermined, right? Because it's like it's only serving its purpose in certain cases, right, selectively. So that is also actually very problematic. So either it's like a lose-lose situation, right, for the ICC in this case, right? And it's, you know, it's the fault of the, you know, the member states, the party states, right, and even the non-party states, right? And you know, basically, if you highlight, you know, the African bias, right, in Bashir's case, it's a cop-out, right? Because you know, African Union representatives, you know, basically they've criticized the ICC, stating that, you know, they've only been looking at human rights violation on the African continent, but you know, ICC basically, you know, is you know, a court that has had more than 30 African states, including South Africa, that were agreeable in the first place, right, in 1998. And don't tell me that, you know, they were not aware that a lot of these crimes against humanity were actually occurring in African soil, and you know, they were fearful, right, about being subsequently targeted by the ICC. So, you know, the logic is that, you know, if it really was an African court, right, then why would, you know, these African states basically have signed up in the first place, right? So, you know, the, you know, rationale also here is that, you know, the Darfur, right, Sudan was basically referred to the ICC via UNSC resolution, right? It was not say like the US referred it, or it was not say like, you know, UK was the one that complained against it and referred it. You know, it was basically a logic, you know, where the UNSC basically decided, right? And the UNSC comprises more of just the US. Yes, the US is very influential, right? But you know, it's more than just the US per se. Okay. All right. So, you know, the logic is that, you know, the lack of cooperation, or like what was mentioned in the video, the earlier video that we saw, you know, the hands and the legs, right? They do not cooperate with the body, right? The member states, you know, the logic here really is that the ICC would only see success in cases like Bashir, right? If you've got the UNSC and the US and other states, right, like the international community, undertaking a sustained effort to prioritize his arrest. And they make it a central part of their diplomatic efforts. If you're going to have states that are going to ignore this, right, then this is obviously not going to work. Now, it's not going to work forever, right? And this is only the first step, right? Post arrest, that's can't even get him to be arrested. But that's only the first step, you know. Post arrest, you have to ensure that all the evidence is collected. No point, you know, letting him run around and then finally you arrest him, and then eventually, you know, after 5-6 years of investigation, say we can't prosecute him because we don't have enough evidence because of a lack of cooperation also, right? You know, you need the cooperation in order to get evidence, right? So, you know, post arrest, you also must ensure that, you know, justice is served and not, you know, denied by simply, you know, citing lack of evidence and say, you know, too bad lah, you know, we have to let him go because we can't do anything about it, right? This has been, you know, a major problem, right? Okay, so you know, so far, there seems, you know, this move by Sudan to say that we will hand him over, you know, it seems to be an attempt by, you know, Sudan to try to normalize its relations with the West, ditch its, you know, pariah nation status, right, and say that we are actually cooperating, right? But you know, it is really quite a delicate situation until we actually see his arrest and start seeing, you know, investigations, right? You know, it's going to be something that is difficult to convince everybody, all right, that, you know, indeed the ICC is, you know, really successful. Okay, so, you know, take a look at this point on the funding, right? Because this is one of the biggest criticisms, you know, of all IOs, right? Spend so much money, right? But you know, still nothing to show for it in that case, right? So, you know, what you want to highlight, right, is that, you know, the absence of the US in particular makes funding of the court extremely expensive, right, for others, right? The US, you know, doesn't support the ICC, you know, directly, but it does share intelligence. It, you know, it does support logistics and so on. But the largest contributions basically come from Japan, France, Germany, Britain, right? And you know, when you look at the ICC, it basically has an annual budget of over 166 million. So far, you know, 4 convictions that they examined, right, had cost $1 billion. So obviously, critics are up in arms. Is it justified or not? The prices, you know, the cost, sorry, not prices. The cost, is it justified? You know, so few situations, 16, you know, 16 investigations, right? You've already spent $1 billion. 16 investigations opened up, many closed cases. You have cases that are withdrawn. Some cases, you know, have actually not convicted anybody. Then you've got states, you know, who are blatantly ignoring the arrest warrants, making them even more, you know, unsuccessful. So that's the main criticism. I like this quote, you know, that highlights what is wrong with this picture. Small fish, few cases, fewer convictions, arrest warrants ignored, all while the court burns millions of dollars in The Hague. Right. I cannot remember where I actually got this from. I think it was a critic's article, a media article on, you know, the ICC, right? You know, but I like the way it was phrased, right? Small fish, few cases, fewer convictions, arrest warrants ignored, all while the court burns millions of dollars in The Hague, right? So, you know, that is what is wrong with that picture. Okay, right? And then this one, the continued opposition, you know, under Trump. Wait, it's just 2 minutes. Let's watch this video. Okay, hold on,
will always act. As my administration has demonstrated, America will always act in our national interests. I spoke before this body last year and warned that the UN Human Rights Council had become a grave embarrassment to this institution, shielding egregious human rights abusers while bashing America and its many friends. Our ambassador to the United Nations, Nikki Haley, laid out a clear agenda for reform, but despite reported and repeated warnings, no action at all was taken. So the United States took the only responsible course. We withdrew from the Human Rights Council, and we will not return until real reform is enacted. For similar reasons, the United States will provide no support in recognition to the International Criminal Court. As far as America is concerned, the ICC has no jurisdiction, no legitimacy, and no authority. The ICC claims near universal jurisdiction over the citizens of every country, violating all principles of justice, fairness, and due process. We will never surrender America's sovereignty to an unelected, unaccountable global bureaucracy. America is governed by Americans. We reject the ideology of globalism, and we embrace the doctrine of patriotism. Around the world, responsible nations must defend against threats to sovereignty, not just from global governments, but also from other new forms of coercion and domination.
The irony, irony of it all.
Madam President.
Wait.
Mr. Secretary General.
Okay, sorry. The irony of it all, right? I do not know, how he stands there and says that with a straight face, especially talking about, like the threat of global governance. Really? How is multilateralism and global governance a threat, right, to individual states? I do not understand this, right? Yeah, obviously. So this logic, of Trump, was, I think, the harshest. If Bush had a reason to do so, based on the environment, right, that was you can't say it's justified, but you understand the rationale behind Bush's stance against the ICC. But with Trump, right, it is really, I think, a misguided, right, harmful policy of an attack on an international judiciary, right, and basically it highlighted, and the logic, that America is governed by America alone, but then America goes around and also imposes its Western defined standards of democracy and capitalism on other states as well. So that's why I mentioned the irony of it all. But basically you see a slight shift away from this under Biden, right? Okay, Trump basically had done a lot to block a lot of investigations, right? So claimed that ICC was basically attacking America's rule of law, but we saw America's rule of law going up in flames, during the BLM and all of these, defund the police and abortion rules and so on, right? And then he claimed that ICC is superfluous, right? And at this point, U.S. administration did not recognize any higher authority than the U.S. Constitution, right? And basically, engage in very petty activities like revoking the U.S. visa. If you have nothing to hide and you're not afraid and you say that we do not bow down to any other authority, then why are you so fearful of letting Fatu Bensouda onto U.S. soil? Right? So the logic is that it's like I do not want to hear anything you say, therefore I block you, right? Which is petty action, this is basically what it amounted to, right? So, those were the criticisms, right? Of continued US opposition. How, it has shifted, slightly under Biden. So I've given you a couple of, links. It doesn't mean that Biden is now going to, change past US response to ICC and going to now be a member state, right? But the logic is that at least there is some opportunities for partial cooperation. Okay, all right. Okay, so a couple of links down here as an overview, right? Giving you some videos and some articles, right? To read, right? Just to pull ideas together and summarize everything. Okay, and I don't want to torture you, right? So I'm just going to give you the question, right? And I've given you also the answer outline one shot, right? Okay, so you can take a look at this, right? How you would likely structure an answer, right? If you have I picked this particular question because I feel that this question is like functions like as an overview for the entire topic, right? Because it basically helps to highlight the strengths and the weaknesses, so it provides a lot of coverage, right? So, and these are the kinds of questions that tend to often come out, right, repeatedly, or in maybe a different form, right? That means maybe the phrasing of the question is slightly different, but the material that you use, right, will be similar to what you see down here. Okay, and with that, I think for the first time in the history of this course, I actually finished 5 minutes before call time, right? It's 2:55, right? And I'm done for today, right? Despite watching some of the videos. Okay, so with this, we've covered basically the last topic, right? The last IO, right? Next week I will do a conclusion, right? Looking at some of the themes, looking at the ideas of the what IOs can do, summarizing some of these ideas and so on, right? So we will look at that next week, right? As by way of conclusion. Okay, all right. If you have any questions, please email me. Okay, and I will see you in class next week. Okay, some people have sent papers. I've returned some. Right, I think someone I think Wayne's paper I've returned already. Right, I think maybe one or two others. Right, I have. I will get them back to you. Okay, all right. Take care, everybody. Bye-bye. Bye. Yep. I hope to get well soon so I can see you all in class next week. Okay? Bye-bye. Bye. Thank you. Bye. Bye. Bye.